Anton Vieltsin, attorney for the Southern District of California. This case deals with prolonged traffic stops and suspicion to search a car. It also deals with consent. In the words of the officer, it does not hurt to ask. July 28, 2017, at about 8:30 p.m., officer pulls over a vehicle for making an illegal left turn. The car is occupied by 3 individuals. Officer spends more than 10 minutes running the plates, checking if there's outstanding warrants, and completing the paperwork. He finds that the driver has a revoked driver's license and no insurance. He gives the driver a ticket and explains that the car can either be impounded or left at the parking lot where the driver initially turned into. There's now some confusion. The driver asks the cop what will happen when he leaves. The officer explains that as long as he does not see the driver operate the vehicle, he essentially doesn't care. The officer hints that someone else can come up and pick up the car. Important to note that at no point did the cop smell alcohol or marijuana. Driver signs some release of liability forms because the car has to be essentially left at this parking lot, and they both acknowledge that they're done now. Then we have the following exchange. Officer asks, "Is there anything illegal in the car?" The guy says, "No." "You mind if I look?" "No, sir. Ain't anything, I promise." "So it's okay for me to search the car?" Driver says, "I mean, shit, I don't care." The officer asks the occupants to step out of the car so he could begin his search. He finds 3 open beer bottles. Mr. Wilson, who was one of the occupants of the car, is told that he will be searched for weapons. Wilson volunteers and says that he has a gun, but does not have a permit for it. He's then charged with possession of a firearm. Mr. Wilson moves to suppress the gun. At the hearing, officer explains why he searched the car. He says a couple of things justified his search. 1, it does not hurt to ask. Number 2, something seemed out of place and I just had to figure it out. And I had the suspicion. I had a feeling, I guess you would call it something. Here's what the court says. We know the stop is legal. Police needs reasonable suspicion to pull over a vehicle. The driver made an illegal turn, nothing to dispute here. In 2015, Supreme Court case Rodriguez, we learned that a traffic stop can become unlawful if it's prolonged beyond a time reasonably required to complete the mission of issuing the ticket for the violation. Officers can still make necessary inquiries such as checking the warrants, driver's licenses, inspecting the registration. There's also some authority that suggests that stops can be prolonged if no one can drive the car away. This is the 11th Circuit case of Vargas. But here the officer resolved the disposition of the car before he asked to search it. Traffic stops can also become consensual if a reasonable person would be free to terminate the encounter. That was also not the case here. The officer had a backup officer who was guarding the car on the side with a flashlight, looking inside. And then the questioning continued. Given that the consent to search was not a product of free choice, officer must have a heightened standard to search the car. We call the standard probable cause. But here the cop could not articulate his probable cause. The court says prolonging a traffic stop because it does not hurt to ask to search a vehicle that the officer stops does not meet reasonable suspicion threshold. That it does not hurt to ask standard is not even unparticularized suspicion. At best, it's a hunch. Extended seizure and vehicle search is unconstitutional. But our analysis does not stop there. In order to challenge a search, the defendant must have standing. He has to show that his Fourth Amendment rights were violated. This is a 1993 Supreme Court case of Padilla. defendant must show that he had expectation of privacy. But the Supreme Court previously articulated that a mere passenger of a car who asserts neither property nor possessory interest in the car generally do not have legitimate expectations of privacy. Mr. Wilson states that he does have a standing. He does not challenge anything that was found in the car. We know that he cannot make a claim that he has expectation of privacy there. He says that he can challenge the search because it's a search of his own person. It is unlikely that the defendant Wilson would ever be asked to get out of the car or searched upon exit of the vehicle absent preparation to search the car. Mr. Wilson was unquestionably seized at all times. This prolonged seizure therefore violated his Fourth Amendment rights. Unless the officers had reasonable suspicion and could articulate it to justify independent seizure of Mr. Wilson, separate and apart from the seizure of the driver, and in this case they did not. Under the fruits of the poisonous tree, evidence obtained as a direct result of an illegal search must be suppressed. So the gun must be suppressed and cannot be used as evidence in this case. If you like this video, click like, click subscribe, and thank you for watching.